Respondeat superior. I bet you didn't guess you'd be speaking Latin by the end of this class, but here we are. Keep going over these Latin words. So, respondeat superior is a legal principle, which means the employer is responsible for the employee, including their actions. So, if I am an employee somewhere and I do something, they can sue me personally, but also my employer. If I punch a customer, you can sue me and also the employer. If I fraud people, they can sue me and they can sue the employer. The point is, the employer is responsible for my actions. So, employers generally don't want to hire people that they think will do bad things. That is why we do background checks. Background checks are not legally required for almost anyone. Yes, teachers need to have background checks, and prison guards have to have background checks, corrections officers. There are a few things where we don't want people working with our kids with terrible criminal backgrounds. But in general, a regular private for-profit company does not have any requirement to do a background check. The risk is, if you don't do the background check, you might end up hiring someone that can cost you a lot of money if they go off the rails. So most companies do background checks. Most of the time when someone says background check, they mean criminal. There are many background checks, and we'll talk about them today. But the first kind we're going to talk about is the criminal one. And what happens is the company doesn't want to be guilty of negligent hiring. Negligent hiring means they hired someone that did harm to someone else, and they should have known better. Negligence in general is you should have known better. You should have taken better care of that person, that thing, that situation, whatever it is. The easiest way to remember how negligence works is ABCD. The A is a little bit wonky. A is a duty. Breach, causation, damages. BCD, breach, causation, damages. And how that works is you had a duty. You had a duty to keep your customers safe. You have a duty to keep your employees safe. You have a duty to do all sorts of things as a company and to keep people safe. B is breach. You didn't do it. You didn't fulfill your duty. You didn't keep people safe. Causation, had you done your job, then there would have been no breach. And damages. Something bad actually happened and now someone is suing you. So that is how negligence works. In an employment sense, it's the same thing, duty, breach, causation, damages, but what is your duty defined as an employer when it comes to negligence. Basically, a standard duty to others exists with respect to taking reasonable steps to avoid hurting unfit employers. The thing about negligence is, and the thing about background checks is, no one's required to do it. But since so many people do it, it's expected. And so if something happened to someone and they were like, you didn't know that about someone? You didn't know your employee has been in jail 3 times for doing the same thing? Most likely, that would be a negligent act on your part. Because most employers check the background and most employers knew, or should have known. If there was only 2 employers in the whole state of Michigan that checked your background, then maybe it wouldn't have been as much of an expectation. But with negligence, what is the general expectation is that you check people's background. So you have a duty to keep people safe, and part of the way you do that, part of the way that most companies do it, is they check their background to make sure they didn't do anything unkosher in the past or something dangerous to employees. Basically, what to look for when you do the background check is knowledge, foreseeability, and public policy. Knowledge is, I knew this person did this thing in the past. Foreseeability is, they could do this again in the future. And public policy is like, is it good public policy? Would it be good for society if these people worked here? If someone was like an axe murderer, but went to prison and became rehabilitated and is like a super nice person now and understands why, what was wrong, and maybe had a mental problem, but now it is fixed, and just, just everything it's fine now. It's taken a long time, and it's fine. Would you still want that person being the fourth grade teacher in an elementary school? I don't know. I don't know if we should have axe murderers as fourth grade teachers, right? So that's like public policy. But basically, for the most part, we look at knowledge and foreseeability. Knowledge, did we know they did something in the past? Foreseeability, could they do it again in the future? That is your duty as an employer, to look and see, do we know something happened? Could they do it? Could they harm my other employees, my customers, themselves, whoever it is in the future? Knowledge, I know they did it in the past or they didn't. That's your duty to find that out. Breach is if you don't do it. Breach. You didn't do your duty. You didn't check their background. You didn't accurately check their background. You didn't thoroughly check their background. You breached. By the way, your criminal records in most states go back 7 years, as far as, they go back forever. But your employer is allowed to go back 7 years. And if you apply for a place, that's usually why they ask you, list everywhere you've lived for the past 7 years, so they can check your criminal record in that place. It's pretty, criminal records are pretty decentralized. So if I look in Michigan, they'll look at that. If something happened in Florida, it's not going to come up on a Michigan search. So if I lived in Florida, I would have to list that, and then they would look in Florida. If I went on vacation in Florida and didn't actually live there, then maybe they won't catch it. But if I was in a jail in Florida, I would have to list that as my address, I guess, for a while. So anyway, it goes back and forth. Either way, the duty, knowledge, foreseeability, did this happen, can it happen again? The breach, didn't check, causation. Listen, I did the thing. I did the thing that you didn't want me to do and that I'd done in the past, which then gives damages. Someone was hurt. Those are the elements of a claim in negligent hiring. Once again, for a claim, there can be a defense, there can be some rebuttal, all that other stuff. But basically what we're worried about is that prima facie case of negligent hiring. That's what someone will have to prove. An example of this is the Never Ready versus Naperville Psychiatric Ventures case. In that case, people were found to, this guy had a history. And he had a history that he should not have been working in a psychiatric hospital, by the way, with underage girls. That kind of was right up his alley, according to what he had done in the past. Now, here's the thing. Knowledge, he had some criminal history, especially with minor girls and drug use and that sort of stuff. Foreseeability, could he do it again? Yeah. I mean, he's going to get a job with access to psychological or psychiatric, I guess, drugs around people of all ages that have mental issues that can be very easily influenced, that are willing to try things that are in there, maybe because they tried things a little too much, who knows, but the knowledge that he did it in the past and the foreseeability that it could happen in the future probably made him not a good candidate for that job. Breach. Naperville Psychiatric Ventures says we checked his background, and they had checked his background according to what he wrote on his application, the social security number and all of that sort of stuff. So as far as causation and damages, there was no breach. They saw it wasn't on the report, so they would have never known, so that, who knows if it never happened in the past, if it could have happened in the future. Except the problem is, it came back. The Social Security Administration came back years later, 6 months later, a long time later, 6 months later, and said, no, this name and Social Security don't match up. So, the taxes you're paying and FICA taxes and those sorts of things aren't going to that account. The name and Social Security number don't match up. They just red flagged it. The hospital did nothing. So now the hospital is on notice that, wait a minute, there's a problem with the social security number. Was it a typo? Did we check the right one? What happened? I don't know. They didn't try to correct it. They didn't ask him, hey, wait, is this what your social security number is? They didn't ask the social security. They couldn't have told much anyway. They didn't compare the social security number that they were paying taxes to the one they did the background check to. They did nothing. And as it turns out, he used a fake background check because he knew he had this criminal past, which would have disqualified from getting a job at this hospital. So, did they do their duty? No. I think they breached their duty. They didn't do their job, they did it originally, and then were notified, no, this isn't right. And they did nothing about it. So it's basically the same as them never checking at all because they knew they had checked the wrong thing and didn't do anything about it anyway. So as far as those causation and damages, yes, a little girl was hurt, and it was because they didn't do their due diligence when hiring him. So that hospital was guilty of negligent hiring. Remember though, felonies, you can rule out felonies. Make a distinction though between felonies and misdemeanors. Those are not nearly as serious. And also especially remember that arrests are protected. The number of times someone is arrested makes no difference. In the United States, you are innocent until proven guilty. Just because you were arrested does not mean you committed a crime. Also, African Americans and Latinos are arrested a lot more than white people and then let go because they were just held for the night. So those arrests are no good. They can be discriminatory, but also they didn't do anything wrong. If they had done something wrong, the way it goes is that they would have been convicted of either a misdemeanor or a felony. You can say whatever you want in your policy as far as we don't hire anyone with a felony, we don't hire anyone with anything at all. We're going to look at it on a situation-by-situation basis. That's fine, but just know, I mean, you kind of limit yourself for some things. If you're not going to ever limit anyone that ever had a misdemeanor, well, at least while I was in college, a ton of my friends got minor in possessions, which I think are misdemeanors. So, are you just going to never hire anyone that ever went to college? Honestly, so. A lot of people get misdemeanors. It happens a lot. A lot of people have some criminal record, especially kind of coming out of college and in their early 20s. So, you can, if you want, not hire anyone with any criminal record at all, but you might be cutting yourself off. So you might want to check your own policy as well. There's also the Fair Credit Reporting Act, which kind of slightly regulates checking the credit of someone as well. When I say slightly regulates, you're allowed to have your own standards for credit as well. But the thing is if you are not hiring someone because of that credit or not promoting them or whatever it is, you have to tell them why. Remember, at will, it's a good reason, bad reason, or no reason at all. You don't have to give someone a reason. If it's because of their credit, you have to tell them. And that's part of the Fair Credit Reporting Act. Fair Credit Reporting Act governs two kinds of credits, either consumer credit reports or investigative reports. Consumer credit is, they check your credit score. And companies are allowed to do this for a lot of people. A few states have rules about who can do that or who you can do that for or who not, but most states don't. And it's probably a good idea to check the credit if you're hiring a CFO, let's say, or someone that's going to be in charge of a lot of money or in charge of cash or that sort of thing. It's probably not worth it for you to pay for a credit report for every employee. If you're a car company and you have 75,000 people putting together cars, what do you care what their credit is? So you can pay for their credit reports if you want, I guess, but it might just not be worth it for the company. Either way, if you're not hiring someone or if you're firing them or not promoting them because of their credit, you have to tell them it's because of their credit. So that's as far as their consumer credit report, checking their credit number, that sort of stuff. The other thing is the investigative report. It's the same information, but they, old school, instead of checking a number, like call around and ask people about the credit worthiness of a person. Have you ever lent money to this person? Hey, bank, did you give that person a mortgage? Did they pay it back? How were they? How, all that sort of stuff. So you can either do it, the investigative reporting is a little bit more in depth because you're actually talking to people and getting sort of a case by case analysis of that person. Whereas a consumer report, it's just one number that tells you allegedly how their credit is. You can do either, but like I said, if you're not going to hire them because of it, you got to tell them that. The next kind of report, or I guess background check, is references. Calling up their old employers and saying, how was this person? How were they at work? And kind of getting the inside scoop. It's kind of the same as the investigative report with your credit, but for references, as we just talk to the old employer or people that they know. A lot of companies very much limit and have strong policies to say you're not allowed to say anything except yes, they worked here or not, or that they no longer work here, or that they're eligible for rehire, or don't even talk to them at all. Make them call this other number, and there's someone at the corporate office whose only job it is to answer those kinds of questions. The reason a lot of companies have those policies of you're not allowed to talk to someone's potential employer is because they don't want a defamation claim. Defamation is when you say something untrue about someone and it hurts them. So if you defamed someone and they didn't get a job because of it, guess what? They can sue the old company for the amount of money they didn't make for the time it took them extra to get a job. So a lot of companies don't want those defamation claims coming in, and you can answer the phone, but a lot of companies have policies against that. Otherwise, a lot of companies are expected to call the old companies to get a reference, to see if they were a good employee, to see if they did what they said they were going to do, or anything that company is going to look for. So the elements of defamation, there are 5 of them. They're elements. You have to prove all of them. So let's talk about it. The first element is someone says something that purports to be factual in nature. They say something and they make it seem like, yes, I'm being serious. This isn't a joke. I'm not kidding around. You asked me a question and I answered it. They say something that purports to be factual in nature. The second thing is it was false or substantially false. It has to be false. If you tell the truth, then that's the truth. That's the whole reason we have references. If someone got in fistfights all the time at work and I tell that to them and they don't get hired, that's the whole point of a reference, is so that the new place doesn't hire them because they don't want someone with fistfights. So the second element is that it does have to be false. Even though the first element, you said it like it was true, it's actually false. The third thing is it does challenge the integrity, character, or ability of the person. If someone said about me, oh, he has blonde hair. Okay, you could say it like it's factual. It's obviously false. I don't know if I'm going to not get hired somewhere because I have blonde hair over dark features. So, it has to actually have an effect on the person. The fourth thing is it was published. By published, I don't mean like, oh no, it was put into a book and printed and sent out. Published just means like told to a third party. I told the next boss. I told a coworker. I told anyone else in the whole world. It has to be, that's publishing it. If you say it out loud, if you write it down, if you send it in a text message, it doesn't matter. If it's told to a third person, that is it being published. And the fifth, of course, is that there is harm. There was an adverse employment action. I didn't get hired because my boss told them I get in fistfights all the time, and that's not true, right? So if that's what they say, then they can be sued by me for defamation. I would have to prove that I don't get in fistfights. I would have to show that they had paperwork from when I got in a fistfight. There's that sort of stuff. But as far as defamation, if I don't get hired for a job because of something false they said about me, I can sue for defamation. So a lot of companies don't want that, which is why they limit the thing a manager can say about someone, because it can be damaging, especially like if there's emotions and the manager doesn't want that person to get another job somewhere else, and so they say bad things, and now they're not getting a job. Yeah, that person can sue the company. Remember, respondeat superior. I didn't get a job because of something my manager said that was false, so I can sue that manager and the company for all the money I'm not making at my new job because I didn't get it because of something false they said about me. I can't stress this enough. It has to be false. A lot of people confuse disparagement and defamation. Saying something bad about someone is not illegal. If it's the truth, if it really happened, like I said, that's the point of a reference. Disparaging comments aren't illegal, they aren't actionable. You can't sue based on them. It has to be a false statement that you made. And that's basically how defamation works. There isn't much of a defense for a company to make other than, oh, I didn't say that, or oh, whatever. But, and the hard part is the plaintiff would have to get from the new employer, like, a reason why they didn't get hired. Oh, because they said you beat people up at work. Oh, can you send me that in an email? Okay, now there's proof that they said that. But defamation. You said something that purported to be true, was actually false. It challenges the character, integrity of the person. It was published to a third party, and there was damages. I didn't get the job. And in the employment aspect, that's how defamation works. There is a qualified privilege with the publishing to a third party part of it. If one company says something to the same company, if one department of the company says something to another department in the same company, it's a qualified privilege, meaning it's not actually defamation, or it is defensible, because it's like the company telling itself. It can't be overly broad, it can't be bombastic, it can't be just like outright lies, but if it was truly like that person thought that thing happened, oh, and by the way, it doesn't matter if that person actually thought I got in fights all the time. If I didn't actually get in fights, it still is defamation. But if that person thought that and then told a different department in the same workplace, I can say, hey, now you're ruining my reputation in a different department over there. It's the same company, so it's not a third party. It would be a separate company. Defamation, maybe I could go after that person individually, but as far as suing the company, that person would have to tell a separate company that whatever that thing is that I was complaining about. Another defense is consent. If I tell the company, like, yeah, you can say whatever you want about me, yeah, you can say, this or that or the other thing, and then I give the job I'm applying for their number, and they say something bad about me or untrue, it depends on the judge whether or not I gave consent. Because if I gave consent, and if I said, yeah, you can tell them I got in a fight, it shouldn't be a big deal in this new place, and they said I got in a fight, then that's consent. And I said, you can tell them that, and then they did. So that is a defense, and they're allowed to say it. If I give consent about like, hey, I'm going to give my new job a number, can you give a referral? And they say, yeah, and I'm like, okay, good, just tell them about me. I don't know what they're going to say. I didn't consent to a part about the fight. I didn't consent to not a part about the fight. I don't have any idea what they're going to say in advance. So that's not real consent. So if they said that I got in fights, they could, influence my next employer, and I could still sue by saying, oh, that's defamation. The best thing to do is to write a letter, right? People might ask, for your number, or ask if you're willing to give a reference or that sort of thing. The best thing to do is to write a letter of recommendation or a referral letter or something like that. And then what happens is that person, that employee, has the choice. I can choose whether or not to give them that letter. If I don't like what the letter says, and it's not as they're talking about fighting, it's not true, whatever it might be, I can just not give it to my next employer. And then if I give it to the next employer, then that is my consent. And if I don't give it, then I don't give consent, and then there's no defamation either, because I didn't tell them that thing, whatever it is in the letter. So that's kind of the best thing to do, is just write the letter as you feel it should be written, and then give it to them, and they can give it to their new employer if they think it's a good letter. So that's the best way to get consent. On the other side of the same coin, by the way, a company can be sued for negligent referral. If a company makes someone seem way better than they actually are because they want to get rid of them, then that can be a negligent referral. Negligent is the same as the negligence as before, but at that point, the new company can sue the old company. What can happen is I might be a great worker, and I might also get in fights. The new employer calls the old employer, and they know I'm a good worker, but also I get in fights, and they're going to get in trouble someday. So on the phone, they say, "Oh my gosh, he's such a great worker. He's like the best person. Oh my gosh," knowing that it's a new employer calling. So then the new employer hires me, and in the first week, I get in a fight. Now the new employer might be like, what? He gets in fights, and you knew that, and you didn't tell me. Your duty is to tell the truth, the whole truth, nothing but the truth. Like, you know, not always like you're in court, but you are, you're expected to tell the whole truth. You breached. You only told them the good things about me. You made me sound a lot better than I actually am, because you probably wanted to get rid of me, and that caused damages at the new work. I got in a fight. So that can be a negligent referral. And now, whatever people sued the new company for, because I beat someone up or whatever it is, that company can sue my old company for it and say, we asked you for a referral, and you gave them a good one, and you didn't tell us you got in fights. If you're gonna say anything, you have to tell the whole truth. Which, coming full circle, that's usually why companies don't allow their managers to say anything, because they don't want the manager to leave someone out. They don't want the manager to say extra stuff. This can come at you from all angles. So once again, best option, letter of recommendation. The person can choose about whether or not they're going to actually give that. And finally, the last kind of background check we're going to talk about today is immigration control. There's the Immigration Reform Control Act, which kind of regulates all of this. For all newly hired workers, you got 3 days to fill out an I-9. 3 days, and the I-9 has to be filled out and filed away. It has to be filled out properly. You have to follow the directions. Companies have been in trouble for not following the directions. It is up to an HR person, whoever the intake person is, to get the documents. You need certain documents for the I-9 they fill out. The employee fills out the top, and the company representative, the HR person, fills out the bottom. And on the bottom is basically the identification that the employee gave you. The employee has to give some sort of picture identifying that like they are the person that's on their ID, and then some sort of citizenship document that proves your citizenship. Your birth certificate is, if you're born in the United States, then you're automatically an American citizen. And so what happens is, your birth certificate doesn't have your picture on it. You have your birth certificate, there's your name, okay, there's your name on your license has your picture, that's who you say you are, okay. It is up to that person, the employee, not the new employee, the company representative, to hand copy the information over as a verification that you read it, that you checked it. It's not just some thing that just you pushed through and did. You looked at this, you copied from one to the other. That's kind of what they're looking for, is to make you look at it. And by the way, if there's a document that proves both it's me and citizenship, then cool, you can use that. I've had a lot of HR people who were told you need to, and they were following directions. I get it, but I always bring my passport. You can't get a United States passport unless you're a citizen, and also it's my picture with my name that I'm applying for the job. Everything is on there. So that is acceptable to the Immigration Service, and it should be acceptable to the company, but there are some people, it happens a lot, that want separate documents as well. But the point is, within 3 days, you have to fill out the I-9 to prove that person is a citizen or has the right to work in the United States, whether it's through a green card or a visa or something like that. Michigan, most states by now also have E-Verify, which is a website you go to, and you're also expected to do that. It logs it, of course, but basically you put in the number, the social security number, the green card number, whatever it is, and it can tell you right away, this is what this person's name is, whether or not they're eligible to work, if they're an American citizen. If they're not an American citizen, it tells you their name, if they're eligible to work, and comes up with their picture, so you can look and see, is this the person standing in front of me? So you have to do that with every single employee when you hire them. Within 3 days for the I-9, and the E-Verify is right away, to make sure that they do have the right to work here, because once again, the company can be held liable if you are employing people who don't have the right to work here. So you have to check their immigration status. Those are the most common and the expected kinds of background checks. Once again, when we're talking about negligence, those are the things that people expect. And if you don't do them, the public might think like, you should look at their criminal background. And because that sentiment is so strong among the public, it is almost a requirement. It's not a legal requirement, it's a negligence requirement, because if you don't do it, you're almost automatically negligent. So I hope this helps for when you're looking to hire people, if one of your first jobs is in recruiting. But those are the sorts of things you got to look for when you're hiring people.